Trump versus the Sussex Sect and Newsom NIMBYs. Dear Pam, Attorney General of the USA. It seems that your boss has taken a little bit of a disliking of Gavin Newsom. So now you have the border, and it would seem been told to ignore Epstein and John F. Kennedy, then we would suggest you take him down via the Sussex Sect. There is just so much to unpack with this sect of thieves. You murderous psychotic Harry, his words where he boasts of the number of people he has killed. To Meghan and Harry taking charity funds, to very dodgy backers. However, today on Master the Blue Chai we are just going to focus on Doria Ragland. The mother, she have a very dodgy background. She was missing for several years during her daughter's teenage years. No tax returns, income. So what could have happened, and what is of immense interest for our dear Pam? Well, we have at least executive overreach and quite likely some illegal activity. Say what? So let's take a deep dive into the murky, corrupt and dishonest world of sealing court records. Now a quick history lesson and for fun civics lesson. The USA is not a traditional country per se but a constitutional federal republic. What that means is it a collection of states with a dual system law-making. Dual system of lawmaking is weird. Laws are created at both the federal and state levels. Federal laws, passed by Congress, signed by the President, or established by federal courts, address national issues and generally take precedence, while state laws, passed by state legislatures, govern matters within their borders, as long as they don't conflict with federal law or the Constitution. So it gets really weird. Take Derek Chauvin, the police officer convicted of second-degree unintentional murder, third-degree murder, second-degree manslaughter, all on the same person, George Floyd, and the federal government had to get in the act, and he was also convicted of violating George's civil rights, specifically depriving him of his constitutional right to be free from unreasonable force by a police officer. Geez, the US is really bonkers, and it makes me think of a joke. I got a $30,000 parking ticket. Yes, $30,000. Sure, it was for parking on a person. Too soon? So in California you have the weird laws and regulations too, specifically around the sealing of criminal records. So when Doria was the guest of the state, she was missing at the same time as her co-workers were inside prison. Yet Doria has no record. So if you look at the court where Doria's co-workers were prosecuted, there are missing records. So records were either lost or sealed. The prison where Doria would have been a guest was paid for more people than it housed. Weird corruption. Nah, it's just what happens where records are sealed. Now Pam, you are from Florida, but that isn't an excuse. You know where we are driving here. So the real question is what, where, how? Now the grand idiot, the king of red hair plugs, Prince Henry, let the cat out of the bag with his correspondence with the great city of New York police, where he repeatedly threatened to involve the office of one Gavin Newsom. The all-powerful Newsom, who made the whole Doria situation disappear. Now this is specifically against the laws of California. Specifically, it is a violation of California Rules of Court 2.550 and 2.551, sealed records, but just like the Queen of QVC Meghan Markle, there is more. Rule 2.550c, court records presumed to be open. This is the fundamental principle. California law starts with the presumption that all court records are public. Any deviation from this requires a strong legal justification. Rule 2.550d express factual findings required to seal records. This is crucial. A court may only order a record sealed if it makes specific, detailed findings that there is an overriding interest, for example, privacy, trade secrets, national security, that outweighs the public's right of access. This overriding interest actually supports sealing the record. There's a substantial probability that the overriding interest will be harmed if the record isn't sealed. The proposed sealing is narrowly tailored, i.e., only the necessary parts are sealed. No less restrictive means exist to achieve the overriding interest. Rule 2.551a, court approval required. A record must not be filed under seal without a court order. The court must not permit a record to be filed under seal based solely on the agreement or stipulation of the parties. This directly states that only a court can order records sealed, and even then, parties can't simply agree to it. A judge must apply the criteria of Rule 2.550d. A governor is not a court and therefore cannot issue such an order. 2. Violation of California Code of Civil Procedure, CCP, Section 124, Public Sittings of Courts, CCP Section 124 states, except as provided in Section 214 of the Family Code or any other provision of law, the sittings of every court shall be public. This statute reinforces the principle of public access to court proceedings and, by extension, the records generated from them. A governor acting to seal records without legal authority would be contravening this statutory mandate. 3. Violation of specific penal code sections governing record sealing/relief. California has specific statutes that allow for certain types of criminal records to be sealed or receive other relief, but these are judicial processes, not executive ones. Penal Code Section 851.8, 851.85, 851.86, 851.91, factual innocence/arrest records. These sections allow for the sealing and sometimes destruction of arrest records, primarily when the person was factually innocent or the arrest did not lead to a conviction. The process involves petitions to the law enforcement agency and, if denied, to the Superior Court. The governor plays no role in this. Penal Code Section 1203.4, expungement/dismissal. This allows for a conviction to be dismissed after successful completion of probation or a sentence. Again, this is a judicial process initiated by a petition to the court, not the governor. Penal Code Section 851.93, 1203.425, automatic record relief/clean slate. These are recent laws that provide for automatic sealing of certain eligible arrest and conviction records after a specified period without new offenses. While signed into law by the governor, the implementation of this is done by the California Department of Justice, DOJ, based on statutory criteria, not by the governor on a case-by-case basis. The governor is not directing the DOJ to seal specific individuals' records outside of these automatic processes. 4. Violation of the doctrine of separation of powers. California Constitution, Article 3, Section 3, the powers of state government are legislative, executive, and judicial. Persons charged with the exercise of one power may not exercise either of the others except as permitted by this Constitution. The act of ordering a court record sealed is fundamentally a judicial function. It involves interpreting law, applying it to facts, and issuing an order that affects the public record. For the governor, executive branch, to issue such an order would be an egregious violation of this constitutional principle, usurping the power specifically reserved for the judiciary. In essence, a governor sealing a court record would be ignoring explicit court rules that dictate the only permissible ways to seal records, overriding existing statutes that place the power to seal records with the courts or the DOJ under specific statutory conditions, directly undermining the foundational principle of public access to court records in California, violating the core principle of the separation of powers, which prevents one branch of government from exercising powers exclusively belonging to another. The legal system has checks and balances precisely to prevent such actions. Any attempt by a governor to do this would be immediately challenged in court by media organizations, civil liberties groups, and potentially the courts themselves, and it would almost certainly be struck down as unlawful. So Pam would refer to one Al Capone, "You have more in this little cesspool to get your man." Remember, this was done before the wedding, before any children, so there is no protection of children, only some rich people's embarrassment. Such government overreach, such misuse of power, it's almost enough to put you off some beautiful homemade crumpets with cinnamon butter and blue chai, almost but not quite. So be like Meghan with cups around staff and smash that like button and bell icon.